paid my dues, time after time. I've done my sentence, but committed no crime.
This will be Volume 2, Introduction, and Section 11 overall. Let's see what the actual title is. Introduction to Volume 2. Okay, here we go.
Section 11 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Section 11, Introduction to Volume 2. Introduction to Volume 2. This report is submitted to the Attorney General pursuant to 28 CFR, Section 600.8c, which states that, quote, at the conclusion of the Special Counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions the Special Counsel reached, unquote. Beginning in 2017, the President of the United States took a variety of actions toward the ongoing FBI investigation into Russia's interference in the 2016 presidential election and related matters that raised questions about whether he had obstructed justice. The order appointing the Special Counsel gave this office jurisdiction to investigate matters that arose directly from the FBI's Russia investigation, including whether the President had obstructed justice in connection with Russia-related investigations. The Special Counsel's jurisdiction also covered potentially obstructive acts related to the Special Counsel's investigation itself. This volume of our report summarizes our obstruction of justice investigation of the President. We first describe the considerations that guided our obstruction of justice investigation and then provide an overview of this volume. First, a traditional prosecution or declination decision entails a binary determination to initiate or decline a prosecution, but we determine not to make a traditional prosecutorial judgment. The Office of Legal Counsel, OLC, has issued an opinion finding that, quote, the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions, unquote, in violation of, quote, the constitutional separation of powers, unquote. Given the role of the Special Counsel as an attorney in the Department of Justice and the framework of the Special Counsel regulations, see 28 U.S.C. Section 515, 28 CFR Section 600.7a, this office accepted OLC's legal conclusion for the purpose of exercising prosecutorial jurisdiction. And apart from OLC's constitutional view, we recognize that a federal criminal accusation against a sitting president would place burdens on the president's capacity to govern and potentially preempt constitutional processes for addressing presidential misconduct. Second, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office, and if individuals other than the president committed an obstruction offense, they may be prosecuted at this time. Given those considerations, the facts known to us, and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available. Third, we considered whether to evaluate the conduct we investigated under the Justice Manual standards governing prosecution and declination decisions, but we determined not to apply an approach that could potentially result in a judgment that the President committed crimes. The threshold step under the Justice Manual standards is to assess whether a person's conduct, quote, constitutes a federal offense, unquote. U.S. Department of Justice Manual, Section 9-27.220, 2018, Justice Manual. Fairness concerns counseled against potentially reaching that judgment when no charges can be brought. The ordinary means for an individual to respond to an accusation is through a speedy and public trial, with all the procedural protections that surround a criminal case. An individual who believes he was wrongly accused can use that process to seek to clear his name. In contrast, a prosecutor's judgment that crimes were committed but that no charges will be brought affords no such adversarial opportunity for public name clearing before an impartial adjudicator. Concerns about the fairness of such a determination would be heightened in the case of a sitting president, where a federal prosecutor's accusation of a crime, even in an internal report, could carry consequences that extend beyond the realm of criminal justice. OLC noted similar concerns about sealed indictments. Even if an indictment were sealed during the president's term, OLC reasoned, quote, it would be very difficult to preserve an indictment's secrecy, unquote, and if an indictment became public, quote, the stigma and opprobrium could imperil the president's ability to govern, unquote. Although a prosecutor's internal report would not represent a formal public accusation akin to an indictment, the possibility of the report's public disclosure and the absence of a neutral adjudicatory forum to review its findings counseled against potentially determining, quote, that the person's conduct constitutes a federal offense, unquote. Justice Manual, Section 9-27.220. Fourth, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment. The evidence we obtained about the President's actions and intent presents difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. This report on our investigation consists of 4 parts. Section 1 provides an overview of obstruction of justice principles and summarizes certain investigatory and evidentiary considerations. Section 2 sets forth the factual results of our obstruction investigation and analyzes the evidence. Section 3 addresses statutory and constitutional defenses. Section 4 states our conclusion. End of Section 11. Recording by Amy Conger, San Francisco, California.
Okay. Section 12. Executive summary. So the summary of this volume. These are small sections.
Section 12 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Section 12. Executive Summary to Volume 2. Our obstruction of justice inquiry focused on a series of actions by the President that related to the Russian interference investigations, including the President's conduct towards the law enforcement officials overseeing the investigations and the witnesses to relevant events. Factual results of the obstruction investigation. The key issues and events we examined include the following. The campaign's response to reports about Russian support for Trump. During the 2016 presidential campaign, questions arose about the Russian government's apparent support for candidate Trump. After WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia, Trump publicly expressed skepticism that Russia was responsible for the hacks, at the same time that he and other campaign officials privately sought information, redacted, harm to ongoing matter, about any further planned WikiLeaks releases. Trump also denied having any business in or connections to Russia, even though, as late as June 2016, the Trump Organization had been pursuing a licensing deal for a skyscraper to be built in Russia called Trump Tower Moscow. After the election, the president expressed concerns to advisors that reports of Russia's election interference might lead the public to question the legitimacy of his election. Conduct involving FBI Director Comey and Michael Flynn. In mid-January 2017, incoming National Security Advisor Michael Flynn falsely denied to the Vice President, other administration officials, and FBI agents that he had talked to Russian Ambassador Sergei Kislyak about Russia's response to U.S. sanctions on Russia for its election interference. On January 27, the day after the president was told that Flynn had lied to the Vice President and had made similar statements to the FBI, the president invited FBI Director Comey to a private dinner at the White House and told Comey that he needed loyalty. On February 14, the day after the president requested Flynn's resignation, the president told an outside advisor, "Now that we fired Flynn, the Russia thing is over." The advisor disagreed and said the investigations would continue. Later that afternoon, the president cleared the Oval Office to have a one-on-one meeting with Comey. Referring to the FBI's investigation of Flynn, the president said, "I hope you can see your way clear to letting this go, to letting Flynn go. He's a good guy. I hope you can let this go." Shortly after requesting Flynn's resignation and speaking privately to Comey, the president sought to have Deputy National Security Advisor K.T. McFarland draft an internal letter stating that the president had not directed Flynn to discuss sanctions with Kislyak. McFarland declined because she did not know whether that was true, and a White House counsel's office attorney thought that the request would look like a quid pro quo for an ambassadorship she had been offered. The president's reaction to the continuing Russia investigation. In February 2017, Attorney General Jeff Sessions began to assess whether he had to recuse himself from campaign-related investigations because of his role in the Trump campaign. In early March, the president told the White House counsel Donald McGahn to stop Sessions from recusing. And after Sessions announced his recusal on March 2, the president expressed anger at the decision and told advisors that he should have an attorney general who would protect him. That weekend, the president took Sessions aside at an event and urged him to unrecuse. Later in March, Comey publicly disclosed at a congressional hearing that the FBI was investigating the Russian government's efforts to interfere in the 2016 presidential election, including any links or coordination between the Russian government and the Trump campaign. In the following days, the president reached out to the Director of National Intelligence and the leaders of the Central Intelligence Agency, CIA, and the National Security Agency, NSA, to ask them what they could do to publicly dispel the suggestion that the president had any connection to the Russian election interference effort. The president also twice called Comey directly, notwithstanding guidance from McGahn to avoid direct contacts with the Department of Justice. Comey had previously assured the president that the FBI was not investigating him personally, and the president asked Comey to lift the cloud of the Russia investigation by saying that publicly. The president's termination of Comey. On May 3, 2017, Comey testified in a congressional hearing, but declined to answer questions about whether the president was personally under investigation. Within days, the president decided to terminate Comey. The president insisted that the termination letter, which was written for public release, stated that Comey had informed the president that he was not under investigation. The day of the firing, the White House maintained that Comey's termination resulted from independent recommendations from the Attorney General and Deputy Attorney General that Comey should be discharged for mishandling the Hillary Clinton email investigation. But the president had decided to fire Comey before hearing from the Department of Justice. The day after firing Comey, the president told Russian officials that he had faced great pressure because of Russia, which had been taken off by Comey's firing. The next day, the president acknowledged in a television interview that he was going to fire Comey regardless of the Department of Justice's recommendation, and that when he decided to just do it, he was thinking that this thing with Trump and Russia is a made-up story. In a response to a question about whether he was angry with Comey about the Russia investigation, the president said, "As far as I'm concerned, I want that thing to be absolutely done properly," adding that firing Comey might even lengthen out the investigation. The appointment of a special counsel and efforts to remove him. On May 17, 2017, the acting attorney general for the Russia investigation appointed a special counsel to conduct the investigation and related matters. The president reacted to the news that a special counsel had been appointed by telling advisors that it was the end of his presidency and demanding that Sessions resign. Sessions submitted his resignation, but the president ultimately did not accept it. The president told aides that the special counsel had conflicts of interest and suggested that the special counsel therefore could not serve. The president's advisors told him the asserted conflicts were meritless and had already been considered by the Department of Justice. On June 14, 2017, the media reported that the special counsel's office was investigating whether the president had obstructed justice. Press reports called this a major turning point in the investigation. While Comey had told the president he was not under investigation, following Comey's firing, the president now was under investigation. The president reacted to this news with a series of tweets criticizing the Department of Justice and the special counsel's investigation. On June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding that he would resign rather than trigger what he regarded as a potential Saturday night massacre. Efforts to curtail the special counsel's investigation. 2 days after directing McGahn to have the special counsel removed, the president made another attempt to affect the course of the Russia investigation. On June 19, 2017, the president met one-on-one in the Oval Office with his former campaign manager, Corey Lewandowski, a trusted advisor outside the government, and directed a message for Lewandowski to deliver to Sessions. The message said that Sessions should publicly announce that, notwithstanding his recusal from the Russia investigation, the investigation was very unfair to the president. The president had done nothing wrong, and Sessions planned to meet with the special counsel and let him move forward with investigating election meddling for future elections. Lewandowski said he understood what the president wanted Sessions to do. 1 month later, in another private meeting with Lewandowski on July 19, 2017, the president asked about the status of his message for Sessions to limit the special counsel investigation to future election interference. Lewandowski told the president that the message would be delivered soon. Hours after that meeting, the president publicly criticized Sessions in an interview with the New York Times, and then issued a series of tweets, making it clear that Sessions' job was in jeopardy. Lewandowski did not want to deliver the president's message personally, so he asked senior White House official Rick Dearborn to deliver it to Sessions. Dearborn was uncomfortable with the task and did not follow through. Efforts to prevent public disclosure of evidence. In the summer of 2017, the president learned that media outlets were asking questions about the June 9, 2016 meeting at Trump Tower between senior campaign officials, including Donald Trump Jr., and a Russian lawyer who was said to be offering damaging information about Hillary Clinton as part of Russia and its government support for Mr. Trump. On several occasions, the president's directed aides not to publicly disclose the emails setting up the June 9 meeting, suggesting that the emails would not leak and that the number of lawyers with access to them should be limited. Before the emails became public, the president edited a press statement for Trump Jr. by deleting a line that acknowledged that the meeting was with an individual who Trump Jr. was told might have information helpful to the campaign, and instead said only that the meeting was about adoptions of Russian children. When the press asked questions about the president's involvement in Trump Jr.'s statement, the president's personal lawyer repeatedly denied the president had played any role. Further efforts to have the Attorney General take control of the investigation. In early summer 2017, the president called Sessions at home and again asked him to reverse his refusal from the Russia investigation. Sessions did not reverse his refusal. In October 2017, the president met privately with Sessions in the Oval Office and asked him to take a look at investigating Clinton. In December 2017, shortly after Flynn pleaded guilty pursuant to a cooperation agreement, the president met with Sessions in the Oval Office and suggested, according to notes taken by a senior advisor, that if Sessions unrecused and took back supervision of the Russia investigation, he would be a hero. The president told Sessions, "I'm not going to do anything or direct you to do anything. I just want to be treated fairly. In response, Sessions volunteered that he had never seen anything improper on the campaign and told the president there was a whole new leadership team in place. He did not unrecuse. Efforts to have McGahn deny that the president had ordered him to have the special counsel removed. In early 2018, the press reported that the president had directed McGahn to have the special counsel removed in June 2017, and that McGahn had threatened to resign rather than carry out the order. The president reacted to the news stories by directing White House officials to tell McGahn to dispute the story and create a record stating that he had not been ordered to have the special counsel removed. McGahn told those officials that the media reports were accurate in stating that the president had directed McGahn to have the special counsel removed. The president then met with McGahn in the Oval Office and again pressured him to deny the reports. In the same meeting, the president also asked McGahn why he had told the special counsel about the president's effort to remove the special counsel, and why McGahn took notes of his conversations with the president. McGahn refused to back away from what he remembered happening, and perceived the president to be testing his mettle. Conduct towards Flynn, Manafort, redacted, harm to ongoing matter. After Flynn withdrew from a joint defense agreement with the president and began cooperating with the government, the president's personal counsel left a message for Flynn's attorneys, reminding them of the president's warm feelings towards Flynn, which he said still remains, and asking for a heads-up if Flynn knew information that implicates the president. When Flynn's counsel reiterated that Flynn could no longer share information pursuant to a joint defense agreement, the president's personal counsel said he would make sure that the president knew that Flynn's actions reflected hostility toward the president. During Manafort's prosecution, and when the jury in his criminal trial was deliberating, the president praised Manafort in public, said that Manafort was being treated unfairly, and declined to rule out a pardon. After Manafort was convicted, the president called Manafort a brave man for refusing to break, and said that flipping almost ought to be outlawed. Redacted, harm to ongoing matter. Conduct involving Michael Cohen. The president's conduct toward Michael Cohen, a former Trump Organization executive, changed from praise to Cohen when he falsely minimized the president's involvement in the Trump Tower Moscow project, to castigation of Cohen when he became a cooperating witness. From September 2015 to June 2016, Cohen had pursued the Trump Tower Moscow project on behalf of the Trump Organization, and had briefed candidate Trump on the project numerous times, including discussing whether Trump should travel to Russia to advance the deal. In 2017, Cohen provided false testimony to Congress about the project, including stating that he had only briefed Trump on the project 3 times, and never discussed travel to Russia with him, in an effort to adhere to a party line that Cohen said was developed to minimize the president's connection to Russia. While preparing for his congressional testimony, Cohen had extensive discussions with the president's personal counsel, who, according to Cohen, said that Cohen should stay on message and not contradict the president. After the FBI searched Cohen's home and office in April 2018, the president publicly asserted that Cohen would not flip, contacted him directly to tell him to stay strong, and privately passed messages of support to him. Cohen also discussed pardons with the president's personal counsel, and believed that if he stayed on message, he would be taken care of. But after Cohen began cooperating with the government in the summer of 2018, the president publicly criticized him, called him a rat, and suggested that his family members had committed crimes. Overarching factual issues. We did not make a traditional prosecution decision about these facts, but the evidence we obtained supports several general statements about the president's conduct. Several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First, the investigation concerned the president, and some of his actions, such as firing the FBI director, involved facially lawful acts within his Article 2 authority, which raises constitutional issues discussed below. At the same time, the president's position as the head of the executive branch provided him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses, all of which is relevant to a potential obstruction of justice analysis. Second, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime related to Russian election interference. Although the obstruction statutes do not require proof of such a crime, the absence of that evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. Third, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, took place in public view. That circumstance is unusual, but no principle of law excludes public acts from the reach of the obstruction laws. If the likely effect of public acts is to influence witnesses or alter their testimony, the harm to the justice system's integrity is the same. Although the series of events we investigated involved discrete acts, the overall pattern of the president's conduct towards the investigations can shed light on the nature of the president's acts and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into 2 phases, reflecting a possible shift in the president's motives. The first phase covered the period from the president's first interactions with Comey through the president's firing of Comey. During that time, the president had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the president became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the president engaged in a second phase of conduct, involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the president's motive during each phase would be informed by the totality of the evidence. Statutory and constitutional defenses. The President's counsel raised statutory and constitutional defenses to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defenses provided a basis for declining to investigate the facts. Statutory defenses. Consistent with precedent in the Department of Justice's general approach to interpreting obstruction statutes, we concluded that several statutes could apply here. See Title 18 United States Code, Sections 1503, 1505, 1512, subsection B3, 1512, subsection C2. Section 1512, subsection C2, is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs the integrity or availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Section 1512, subsection B, aimed specifically at conduct intended to prevent or hinder the communication to law enforcement of information related to a federal crime. Constitutional defenses. As for constitutional defenses arising from the President's status as the head of the executive branch, we recognized that the Department of Justice and the courts have not definitively resolved these issues. We therefore examined those issues through the framework established by Supreme Court precedent governing separation of powers issues. The Department of Justice and the President's personal counsel have recognized that the President is subject to statutes that prohibit obstruction of justice by bribing a witness or suborning perjury, because that conduct does not implicate his constitutional authority. With respect to whether the President can be found to have obstructed justice by exercising his powers under Article 2 of the Constitution, we concluded that Congress has the authority to prohibit a President's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article 2 powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt obstructive acts, regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the president's ability to fulfill his constitutional mission. The term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A preclusion of corrupt official action does not diminish the president's ability to exercise Article 2 powers. For example, the proper supervision of criminal law does not demand freedom for the president to act with a corrupt intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers, rather than hinders, the impartial and even-handed administration of the law. It also aligns with the president's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the president's conduct is justified, inquiries to determine whether the president acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office accords with our constitutional systems of checks and balances and the principle that no person is above the law. Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the president's conduct. The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him. End of section 12.
And we're going to start section 13. Section 13 will be probably Attorney Dye's favorite section, background and evidentiary principles. All right, here we go.
Section 13. 1. Background and evidentiary principles of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller, Section 13. 1. Background, legal, and evidentiary principles. A. Legal framework of obstruction of justice. The May 17, 2017 appointment order and the special counsel regulations provide this office with jurisdiction to investigate, quote, federal crimes committed in the course of and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses, end quote. 28 CFR section 600.4a. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. See Justice Manual, Section 9-27.000 et sec. 2018. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report addressing constitutional defenses that the President's counsel have raised. See Volume 2, Section 3.b, Infra. Three basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding. And 3. A corrupt intent. See, e.g., 18 U.S.C. sections 1503, 1505, 1512 C2. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering. See 18 U.S.C. section 1512b, and describe the requirements for attempted offenses and endeavors to obstruct justice. See 18 U.S.C. sections 1503, 1512 C2. Obstructive act. Obstruction of justice law, quote, reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered regardless of the means employed, end quote. United States v. Silverman, 745 F. 2nd, 1386, 1393, 11th Circuit, 1984, interpreting 18 U.S.C. section 1503. An effort to influence a proceeding can qualify as an endeavor to obstruct justice, even if the effort was subtle or circuitous, and, however cleverly or with whatever cloaking of purpose, it was made. United States v. Roe, 529 F. 2nd, 629, 632, 4th Circuit, 1975. See also United States v. Quattroni, 441 F. 3rd, 153, 173, 2nd Circuit, 2006. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. Marinello v. United States, 138 Supreme Court, 1101, 1106, 2018. An improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful and within the actor's authority. See United States v. Cueto, 151 Federal 3rd, 620, 631, 7th Circuit, 1998. Affirming obstruction conviction of a criminal defense attorney for litigation-related conduct. United States v. Sintolo, 818 F. 2nd, 980, 992, 1st Circuit, 1987. Quote, any act by any party, whether lawful or unlawful on its face, may abridge section 1503 if performed with a corrupt motive. End quote. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding. In Section 1503, the nexus must be to pending judicial or grand jury proceedings. United States v. Aguilar, 515 U.S. 593, 599, 1995. In Section 1505, the nexus can include a connection to a pending federal agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. Id at 599. See also Arthur Anderson LLP versus United States, 544 U.S. 696, 707 to 708, 2005. Section 512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. 18 U.S.C. Section 1515A1A. Quote, for purposes of, Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. End quote. 18 U.S.C. Section 1512 Act 1. Although a proceeding need not already be in progress to trigger liability under Section 1512C, a nexus to a contemplated proceeding must still be shown. United States v. Young, 916 F. 3rd, 368, 386, 4th Circuit, 2019. United States v. Petrick, 781, F. 3rd, 438, 445, 8th Circuit, 2015. United States v. Phillips, 583, F. 3rd, 1261, 1264, 10th Circuit, 2009. United States v. Reich, 479, F. 3rd, 179, 186, 2nd Circuit, 2007. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. Aguilar, 515 U.S. at 600. The nexus showing has subjective and objective components. As an objective matter, a defendant must act, quote, in a manner that is likely to obstruct justice, end quote, such that the statute, quote, excludes defendants who have an evil purpose, but use means that would only unnaturally and improbably be successful, end quote. Aguilar, 515 U.S. at 601, 602. Emphasis added. Quote, the endeavor must have the natural and probable effect of interfering with the due administration of justice, end quote. Id at 599. As a subjective matter, the actor must have, quote, contemplated a particular foreseeable proceeding, end quote, Petrick, 781, F. 3rd at 445, 446. A defendant need not directly impede the proceeding. Rather, a nexus exists if, quote, discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding, end quote. United States v. Martinez, 864 F. 3rd, 223, 228, 2nd Circuit, 2017. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly or with an improper motive. United States v. Richardson, 676 F. 3rd, 491, 508, 5th Circuit, 2012. United States v. Gordon, 710 F. 3rd, 1124, 1151, 10th Circuit, 2013. To act corruptly means to, quote, act with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct, end quote, the relevant proceeding. See 18 U.S.C. Section 1515b. Quote, as used in Section 1505, the term corruptly means acting with an improper purpose, personally, or by influencing another, end quote. See also Arthur Anderson, 544 U.S. at 705 to 706. Interpreting corruptly to mean wrongful, immoral, depraved, or evil, and holding that acting knowingly, corruptly, in 18 U.S.C. Section 1512b, requires consciousness of wrongdoing. The requisite showing is made when a person acted with an intent to obtain improper advantage for himself or someone else, inconsistent with official duty and the rights of others. Ballantyne's Law Dictionary, 276, 3rd edition, 1969. See United States v. Pasha, 797 F. 3rd, 1122, 1132, D.C. Circuit, 2015. Aguilar, 515 U.S. at 616. Scalia J. concurring in part and dissenting in part, characterizing this definition as the long-standing and well-accepted meaning of corruptly. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. See 18 U.S.C. Section 1512b 1 and 3. Making it a crime to knowingly use intimidation or corruptly persuade another person or engage in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of any person in an official proceeding, or to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a federal offense. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. United States v. Edlin, 887 F. 3rd, 166, 174, 4th Circuit, 2018. United States v. Sparks, 791 F. 3rd, 1188, 1191, 1192, 10th Circuit, 2015. United States v. Byrne, 435 F. 3rd, 16, 23 to 26, 1st Circuit, 2006. United States v. Lachey, 417 F. 3rd, 715, 718 to 719, 7th Circuit, 2005. United States v. Burns, 298 F. 3rd, 523, 539 to 540, 6th Circuit, 2002. United States v. Pennington, 168 F. 3rd, 1060, 1066, 8th Circuit, 1999. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons. Sparks 791 F. 3rd at 1192. Or coach or remind witnesses by planting misleading facts. Edlund 887 F. 3rd at 174. Corrupt persuasion is shown, quote, where a defendant tells a potential witness a false story as if the story were true, intending that the witness believe the story and testify to it, end quote. United States versus Rodolitz, 786 F. 2nd, 77, 82, 2nd Circuit, 1986. See United States versus Gabriel, 125 F. 3rd, 89, 102, 2nd Circuit, 1997. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. See Lachey, 417 F. 3rd at 719. Corrupt persuasion can also be shown in certain circumstances when a person, with an improper motive, urges a witness not to cooperate with law enforcement. See United States versus Schatz, 145 F. 3rd, 1289, 1301, 11th Circuit, 1998, telling Secretary, quote, not to say anything to the FBI, and she would not be bothered. When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a preceding inquiry articulated in Aguilar that an individual have, quote, knowledge that his actions are likely to affect the judicial proceeding, end quote, 515 U.S. at 599, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing. Arthur Anderson, 544 U.S. at 705 to 706, declining to explore, quote, the outer limits of this element, unquote, but indicating that an instruction was infirm where it permitted conviction, even if the defendant, quote, honestly and sincerely believed that the conduct was lawful. It is an affirmative defense that, quote, the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. 18 U.S.C. Section 1512E. Attempts and endeavors. Section 1512C2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step toward that goal. See United States versus Resende Pons, 549 U.S. 102, 106 to 107, 2007. Quote, the act must be substantial in that it was strongly corroborative of the defendant's criminal purpose. Quote, United States versus Pratt, 351 F. 3rd, 131, 135, 4th Circuit, 2003. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. United States versus Irving, 665 F. 3rd, 1184, 1198 to 1205, 10th Circuit, 2011. Thus, quote, soliciting an innocent agent to engage in conduct constituting an element of the crime, unquote, may qualify as a substantial step. Model Penal Code, Section 5.01(2)G. See United States versus Lucas, 499 F. 3rd, 769, 781, 8th Circuit, 2007. The Omnibus Clause of 18 U.S.C. Section 1503 prohibits an endeavor to obstruct justice, which sweeps more broadly than Section 1512's attempt provision. See United States versus Sampson, 898 F. 3rd, 287, 302, 2nd Circuit, 2018. United States versus Leisure, 844 F. 2nd, 1347, 1366 to 1367, 8th Circuit, 1988, collecting cases. Quote, it is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. United States versus Davis, 854 F. 3rd, 1276, 1292, 11th Circuit, 2017. B. Investigative and evidentiary considerations. After the appointment of the special counsel, this office obtained evidence about the following events relating to potential issues of obstruction of justice involving the president. A. The president's January 27, 2017 dinner with former FBI Director James Comey, in which the president reportedly asked for Comey's loyalty, one day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B. The president's February 14, 2017 meeting with Comey, in which the president reportedly asked Comey not to pursue an investigation of Flynn. C. The President's private requests to Comey to make public the fact that the President was not the subject of an FBI investigation and to lift what the President regarded as a cloud. D. The President's outreach to the Director of National Intelligence and the Directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. E. The President's stated rationales for terminating Comey on May 9, 2017, including statements that could be reasonably understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination, and F. The President's reported involvement in issuing a false statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and admitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information and our analysis of applicable statutory and constitutional principles discussed below in Volume 2, Section 3, infra, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the President. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested that the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information, and we interviewed other witnesses who had pertinent knowledge, obtained documents on a voluntary basis when possible, and used legal process where appropriate. These investigative steps allowed us to gather a substantial amount of evidence. We also sought a voluntary interview with the President. After more than a year of discussion, the President declined to be interviewed. Redaction, grand jury. During the course of our discussions, the President did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believe that we have the authority and legal justification to issue a grand jury subpoena to obtain the President's testimony, we chose not to do so. We made this decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that, based on the significant body of evidence we had already obtained of the President's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the President's testimony. The office's decision-making process on this issue is described in more detail in Appendix C, infra, in a note that precedes the President's written responses. In assessing the evidence we obtained, we relied on common principles that apply in any investigation. The issue of criminal intent is often inferred from circumstantial evidence. See, e.g., United States v. Croteau, 819 F. 3rd, 1293, 1305, 11th Circuit, 2016. Quote, guilty knowledge can rarely be established by direct evidence. Therefore, mens rea elements such as knowledge or intent may be proved by circumstantial evidence. Unquote. United States v. Robinson, 702 F. 3rd, 2236, 2nd Circuit, 2012. Quote, the government's case rested on circumstantial evidence, but the mens rea elements of knowledge and intent can often be proved through circumstantial evidence and the reasonable inferences drawn therefrom. End quote. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment, and therefore decline to testify. Accordingly, determinations on intent are frequently reached without the opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule. See, e.g., Edlund 887 F. 3rd at 174-176, relying on, quote, significant circumstantial evidence that the defendant was conscious of her wrongdoing, unquote, in an obstruction case. Quote, because evidence of intent will almost always be circumstantial, a defendant may be found culpable where the reasonable and foreseeable consequences of her acts are the obstruction of justice. Quattroni, 441 F. 3rd at 173-174. Circumstantial evidence that illuminates intent may include a pattern of potentially obstructive acts. Federal Rules of Evidence, 404B. Quote, evidence of a crime, wrong, or other act may be admissible to prove motive, opportunity, intent, preparation, planning, knowledge, identity, absence of mistake, or lack of accident. End quote. See, e.g., United States v. Frankhauser, 80 F. 3rd, 641, 648 to 650, 1st Circuit, 1996. United States v. Arnold, 773 F. 2nd, 823, 832 to 834, 7th Circuit, 1985. Sintolo, 818 F. 2nd, at 1000. Credibility judgments may also be made based on objective facts and circumstantial evidence. Standard jury instructions highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had a reason not to tell the truth, whether the witness had a good memory, whether the witness had the opportunity to observe the events about which he testified, whether the witness's testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. See, e.g., First Circuit Pattern Jury Instructions, Section 1.06, 2018. Fifth Circuit Pattern Jury Instructions, Criminal Cases, Section 1.08, 2012. Seventh Circuit Pattern Jury Instructions, Section 3.01, 2020. In addition to those general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of the facts. For example, contemporaneous written notes can provide strong corroborating evidence. See United States v. Nobles, 422 U.S. 225, 232, 1975. The fact that a, quote, statement appeared in the contemporaneously recorded report would tend to strongly corroborate the investigator's version of the interview, unquote. Similarly, a witness's recitation of his account before he had any motive to fabricate also supports the witness's credibility. See Tome v. United States, 513 U.S. 150, 158, 1995. Quote, a consistent statement that predates the motive is a square rebuttal of the charge that the testimony was contrived as a consequence of that motive, end quote. Finally, a witness's false description of an encounter can imply consciousness of wrongdoing. See Al-Adal v. Obama, 613 F. 3rd, 1102, 1107, D.C. Circuit, 2010, noting the, quote, well-settled principle that false exculpatory statements are evidence, often strong evidence, of guilt. We applied those settled legal principles in evaluating the factual results of our investigation. End of Section 13. Recording by Amy Conger, San Francisco, California.
Okay. Section 14. Executive summary. Yeah. The factual result of the obstruction investigation, Section A. This is the first part of the investigation. It's only 22 minutes. The second one's 59 minutes, so we'll do that the next time. Here's Part A.
Section 14A of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Lynn Jarrow. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Volume 2. Factual Results of the Obstruction Investigation. This section of the report details the evidence we obtained. We first provide an overview of how Russia became an issue in the 2016 presidential campaign, and how candidate Trump responded. We then turn to the key events that we investigated: the president's conduct concerning the FBI investigation of Michael Flynn, the president's reaction to public confirmation of the FBI's Russia investigation, events leading up to and surrounding the termination of FBI Director Comey, efforts to terminate the special counsel, efforts to curtail the scope of the special counsel's investigation, efforts to prevent disclosure of information about the June 9, 2016 Trump Tower meeting between Russians and senior campaign officials, efforts to have the Attorney General unrecuse, and conduct towards McGahn, Cohen, and other witnesses. We summarize the evidence we found and then analyze it by reference to the three statutory obstruction of justice elements: obstructive act, nexus to a proceeding, and intent. We focus on elements because, by regulation, the special counsel has jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Title 28 Code of Federal Regulations 600.4a. Consistent with our jurisdiction to investigate federal obstruction crimes, we gathered evidence that is relevant to the elements of those crimes and analyzed them within an elements framework, while refraining from reaching ultimate conclusions about whether crimes were committed for the reasons explained above. This section does not address legal and constitutional defenses raised by counsel for the president. Those defenses are analyzed in Volume 2, Section 3. Section A. The campaign's response to reports about Russian support for Trump. During the 2016 campaign, the media raised questions about a possible connection between the Trump campaign and Russia. The questions intensified after WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia. Trump responded to questions about possible connections to Russia by denying any business involvement in Russia, even though the Trump Organization had pursued a business project in Russia as late as June 2016. Trump also expressed skepticism that Russia had hacked the emails at the same time as he and other campaign advisors privately sought information, redacted, harm to ongoing matter, about any further planned WikiLeaks releases. After the election, when questions persisted about possible links between Russia and the Trump campaign, the president-elect continued to deny any connections to Russia and privately expressed concerns that reports of Russian election interference might lead the public to question the legitimacy of his election. 1. Press reports allege links between the Trump campaign and Russia. On June 16, 2015, Donald J. Trump declared his intent to seek nomination as the Republican candidate for president. By early 2016, he distinguished himself among Republican candidates by speaking of closer ties with Russia, saying he would get along well with Russian President Vladimir Putin, questioning whether the NATO alliance was obsolete, and praising Putin as a strong leader. The press reported that Russian political analysts and commentators perceived Trump as favorable to Russia. Beginning in February 2016 and continuing through the summer, the media reported that several Trump campaign advisors appeared to have ties to Russia. For example, the press reported that campaign advisor Michael Flynn was seated next to Vladimir Putin at an RT gala in Moscow in December 2015, and that Flynn had appeared regularly on RT as an analyst. The press also reported that foreign policy advisor Carter Page had ties to a Russian state-run gas company, and that campaign chairman Paul Manafort had done work for the Russian-backed former Ukrainian president Viktor Yanukovych. In addition, the press raised questions during the Republican National Convention about the Trump campaign's involvement in changing the Republican platform stance on giving weapons to Ukraine to fight Russian and rebel forces. 2. The Trump campaign reacts to WikiLeaks' release of hacked emails. On June 14, 2016, a cybersecurity firm that had conducted in-house analysis for the Democratic National Committee, DNC, posted an announcement that Russian government hackers had infiltrated the DNC's computer and obtained access to documents. On July 22, 2016, the day before the Democratic National Convention, WikiLeaks posted thousands of hacked DNC documents revealing sensitive internal deliberations. Soon thereafter, Hillary Clinton's campaign manager publicly contended that Russia had hacked the DNC emails and arranged their release in order to help candidate Trump. On July 26, 2016, the New York Times reported that U.S. intelligence agencies had told the White House they now have high confidence that the Russian government was behind the theft of emails and documents from the Democratic National Committee. Within the Trump campaign, aides reacted with enthusiasm to reports of the hacks, redacted, harm to ongoing matter, discussed with campaign officials that WikiLeaks would release the hacked material. Some witnesses said that Trump himself discussed the possibility of upcoming releases, redacted, harm to ongoing matter. Michael Cohen, then executive vice president of the Trump Organization and special counsel to Trump, recalled hearing, redacted, harm to ongoing matter. Cohen recalled that Trump responded, "Oh, good, all right," and redacted, harm to ongoing matter. Manafort said that shortly after WikiLeaks' July 22, 2016 release of hacked documents, he spoke to Trump, redacted, harm to ongoing matter. Manafort recalled that Trump responded that Manafort should, redacted, harm to ongoing matter, keep Trump updated. Deputy campaign manager Rick Gates said that Manafort was getting pressure about, redacted, harm to ongoing matter, information, and that Manafort instructed Gates, redacted, harm to ongoing matter, status updates on upcoming releases. Around the same time, Gates was with Trump on a trip to an airport, redacted, harm to ongoing matter. And shortly after the call ended, Trump told Gates that more releases of damaging information would be coming, redacted, harm to ongoing matter, were discussed within the campaign. And in the summer of 2016, the campaign was planning a communication strategy based on the possible release of Clinton emails by WikiLeaks. 3. The Trump campaign reacts to allegations that Russia was seeking to aid candidate Trump. In the days that followed WikiLeaks' July 22, 2016 release of hacked DNC emails, the Trump campaign publicly rejected suggestions that Russia was seeking to aid candidate Trump. On July 26, 2016, Trump tweeted that it was crazy to suggest that Russia was dealing with Trump, and that, for the record, he had zero investments in Russia. In a press conference the next day, July 27, 2016, Trump characterized this whole thing with Russia as a total deflection and stated that it was far-fetched and ridiculous. Trump said that the assertion that Russia had hacked the emails was unproven, but stated that it would give him no pause if Russia had Clinton's emails. Trump added, "Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press." Trump also said that there's nothing that I can think of that I'd rather do than have Russia friendly, as opposed to the way they are right now. And in response to a question about whether he would recognize Crimea as Russian territory and consider lifting sanctions, Trump replied, "We'll be looking at that. Yeah, we'll be looking." During the press conference, Trump repeated, "I have nothing to do with Russia," 5 times. He stated that the closest he came to Russia was that Russians may have purchased a home or condos from him. He said that after he held the Miss Universe pageant in Moscow in 2013, he had been interested in working with Russian companies that wanted to put a lot of money into developments in Russia, but it never worked out. He explained, "Frankly, I didn't want to do it for a couple of different reasons. But we had a major developer that wanted to develop property in Moscow and other places, but we decided not to do it." The Trump organization, however, had been pursuing a building project in Moscow, the Trump Tower Moscow project, from approximately September 2015 through June 2016. And the candidate was regularly updated on developments, including possible trips by Michael Cohen to Moscow to promote the deal, and by Trump himself to finalize it. Cohen recalled speaking with Trump after the press conference about Trump's denial of any business dealings in Russia, which Cohen regarded as untrue. Trump told Cohen that Trump Tower Moscow was not a deal yet and said, "Why mention it if it is not a deal?" According to Cohen, at around this time, in response to Trump's disavowal of connections to Russia, campaign advisors had developed a party line that Trump had no business with Russia and no connections to Russia. In addition to denying any connections with Russia, the Trump campaign reacted to reports of Russian election interference in aid of the campaign by seeking to distance itself from Russian contacts. For example, in August 2016, Foreign Policy Advisor J.D. Gordon declined an invitation to Russian Ambassador Sergei Kislyak's residence because the timing was not optimal, in view of media reports about Russian interference. On August 19, 2016, Manafort was asked to resign amid media coverage scrutinizing his ties to a pro-Russian political party in Ukraine and links to Russian business. And when the media published stories about Page's connection to Russia in September 2016, Trump campaign officials terminated Page's association with the campaign and told the press that he had played no role in the campaign. On October 7, 2016, WikiLeaks released the first set of emails stolen by a Russian intelligence agency from Clinton campaign chairman John Podesta. The same day, the federal government announced that the Russian government directed the recent compromises of emails from U.S. persons and institutions, including from U.S. political organizations. The government statement directly linked Russian hacking to the releases on WikiLeaks with the goal of interfering with the presidential election, and concluded that only Russia's senior-most officials could have authorized these activities based on their scope and sensitivity. On October 11, 2016, Podesta stated publicly that the FBI was investigating Russia's hacking and said that candidate Trump might have known in advance that the hacked emails were going to be released. Vice presidential candidate Mike Pence was asked whether the Trump campaign was in cahoots with WikiLeaks in releasing damaging Clinton-related information, and responded, "Nothing could be further from the truth." 4. After the election, Trump continues to deny any contacts or connections with Russia or that Russia aided his election. On November 8, 2016, Trump was elected president. 2 days later, Russian officials told the press that the Russian government had maintained contacts with Trump's immediate entourage during the campaign. In response, Hope Hicks, who had been the Trump campaign spokesperson, said, "We are not aware of any campaign representatives that were in touch with any foreign entities before yesterday, when Mr. Trump spoke with many world leaders." Hicks gave an additional statement denying any contacts between the campaign and Russia. "It never happened. There was no communication between the campaign and any foreign entity during the campaign." On December 10, 2016, the press reported that U.S. intelligence agencies had concluded that Russia interfered in last month's presidential election to boost Donald Trump's bid for the White House. Reacting to the story the next day, President-elect Trump stated, "I think it's ridiculous. I think it's just another excuse." He continued that no one really knew who was responsible for the hacking, suggesting that the intelligence community had no idea if it's Russia or China or somebody. It could be somebody sitting in a bed someplace. The president-elect also said the Democrats were putting out the story of Russian interference because they suffered one of the greatest defeats in the history of politics. On December 18, 2016, Podesta told the press that the election was distorted by the Russian intervention and questioned whether Trump campaign officials had been in touch with the Russians. The same day, incoming Chief of Staff Reince Priebus appeared on Fox News Sunday and declined to say whether the president-elect accepted the intelligence community's determination that Russia intervened in the election. When asked about any contact or coordination between the campaign and Russia, Priebus said, "Even this question is insane. Of course we didn't interface with the Russians." Priebus added that this whole thing is a spin job and said the real question is why the Democrats are doing everything they can to delegitimize the outcome of the election. On December 29, 2016, the Obama administration announced that in response to Russian cyber operations aimed at the U.S. election, it was imposing sanctions and other measures on several Russian individuals and entities. When first asked about the sanctions, President-elect Trump said, "I think we ought to get on with our lives." He then put out a statement that said, it's time for our country to move on to bigger and better things, but indicated that he would meet with intelligence community leaders the following week for a briefing on Russian interference. The briefing occurred on January 6, 2017. Following the briefing, the intelligence community released the public version of its assessment, which concluded with high confidence that Russia had intervened in the election through a variety of means with the goal of harming Clinton's electability. The assessment further concluded with high confidence that Putin and the Russian government had developed a clear preference for Trump. Several days later, BuzzFeed published unverified allegations compiled by former British intelligence officer Christopher Steele during the campaign about candidate Trump's Russia connections under the headline, "These reports allege Trump has deep ties to Russia." In a press conference the next day, the president-elect called the release an absolute disgrace and said, "I have no dealings with Russia. I have no deals that could happen in Russia because we've stayed away. So I have no deals, I have no loans, and I have no dealings. We could make deals in Russia very easily if we wanted to. I just don't want to because I think that would be a conflict." Several advisors recalled that the president-elect viewed stories about his Russian connections, the Russia investigations, and the intelligence community assessment of Russian interference as a threat to the legitimacy of his electoral victory. Hicks, for example, said that the president-elect viewed the intelligence community assessment as his Achilles heel because even if Russia had no impact on the election, people would think Russia helped him win, taking away from what he had accomplished. Sean Spicer, the first White House communications director, recalled that the president thought the Russia story was developed to undermine the legitimacy of his election. Gates said the president viewed the Russia investigation as an attack on the legitimacy of his win. And Priebus recalled that when the intelligence assessment came out, the president-elect was concerned people would question the legitimacy of his win. End of section 14A.
Okay. The legitimacy of his win. Ah! So laughable. Oh, wow. Okay. Okay, that's everything. That's everything we're going to cover today. But yeah, you're right. Nothing to see here. There was no Russian involvement. They didn't talk to the Russians all the time. No, not any of them. That's why they were using not the leaders, but underneath them, the underlings to do it, and Don Jr. and people like that, so that they could say, "We don't know what they were doing. That was them. That wasn't us." Even though he was doing the freaking place. Oh yeah, he's still doing it. Yes. And our Congress is like, "Oh no, nothing here, nothing here, nothing here." But yeah, it's not just the phone calls, everything. His contracts, everything else that he was supposed to do away with. He wasn't supposed to do those deals.
The national debt continues rising higher every second. Trillions upon trillions borrowed against the future.
Right into it. Okay. Who's live? Okay, Mother Hen's live now, but any more discussion, or you think we should end this and go to the lives? Yeah, they said specific things. This is when they were still on top of things. Okay. Talk to you later then. Oh. Did you want to come up? I thought you were going down.
Wanted to talk about it.
Oh, you wanted to talk about it, huh?
Yeah, let's talk about it.
I wish Attorney Dad would have stayed around longer because I would have liked to get a hearing on some of that.
Right. Not the double talk in the background, damn it.
Oh, hold on. Is it still there?
Is it there? Yep, still there.
Yeah, okay. We'll just have to mute and unmute.
Okay. But if you listen carefully, it's all these specific keywords that they even tied in from other cases. So it's not like they didn't try to pin them on something, but it's always a specific wording. You're on mute.
I realized I was on mute when I was saying that.
Good job.
Yeah, they always do that. If you notice, you go case to case, you'll see them actually doing things like that. I've drawn it to. All right, just a second. Let's see if I can do this. Okay, can you hear me? Now you should have no background.
I hope not. Nope, no background. Just on your end.
Yeah, I switched over.
Okay. But yeah, it's, it's hard to pin them down. But, they at least tried in all these different cases to find the different words. They'll nail him. They will nail him one of these days.
Okay. Kill. Now it should be totally good.
Oh, good job.
Then switch over to the Bluetooth. But
still, no involvement at all. But if you always recall, even the last time that he was in Russia exactly was for that pageant in 2013.
Mm-hmm.
So that was when he was the last time physically in Russia.
Yeah.
But still, he met up in Alaska. He met up in all these other different countries as well with these other officials.
Mm-hmm.
Now, based on also the business that they were necessarily doing, but also side quests.
Oh, yeah.
It's always a side quest. They're the most important for these specific meetings, not the little peddly shit in between.
And the other thing is, it's like I said, we have to pay attention to the island speak. They say, "Oh, we're going to meet." They went to meet at the island.
Mm-hmm.
That was another way that they could get information back and forth, because that's what was happening. They were using the lackeys to make it look like there was nothing. That they were doing it on their own when they were passing real information other ways. But during that time, he was still coherent enough to keep it quiet. Because if you remember, he
stay on message.
Yeah, he stayed on at that point, but now they can't. Which is why more and more of this stuff's coming out, because he can't stay on message. So
stay on message. Distract. Delay.
But yeah, they've lost a lot of that.
And it's intentional. It's also a learned tactic. Mm-hmm. How the FBI got, actually pinpointed shit on the mob people. Mm-hmm. It's the same crap.
But see, I think the more we get into this, you see, evidence was there.
In a roundabout way, yes.
And they didn't push it further.
But it's all roundabout. It's not like pinpointed specific wording to prosecute. Like they said, they pulled up all these different cases. They pulled up, the key words for these things that they thought can relate to the situation, but it doesn't necessarily pin them down.
Oh yeah, but
and that's what I'm learning, and just by listening into these reports too. Yeah. Just knowing him and what those administrations have been doing since, and his team has been doing since. It's just all the roundabout circle.
Oh yeah, they keep going. They hide behind different things.
Mm-hmm. And this is the loopholes that they made, or these are loopholes that his lawyers have said that, hey, you could get away with this, but by not saying this, but if you do these actions, you could get away with doing this. Yeah, well, so who's really advising him on this? Duh. Pinpoint who's advising, but the actions are also still speaking louder than words.
Well, Cohen.
Mm-hmm. Well, he was a good insider for it, but
he was a snake. He's a snake in the grass.
Yeah, always was. Banning another one too.
Yeah. But Cohen's issue was he didn't have the backbone his father did. His father did a lot of the stuff in the beginning, and if Cohen would have had his backbone, I don't think we would have found out about this so much later.
And Parnas's, father was another one too that was involved. Mm-hmm. As far as lackeys are concerned, yeah, he was a lackey.
He didn't have the backbone his father had. That's the thing. And I think the difference was is Cohen's father was in the day when they actually had a real mafia,
Right.
and he was part of the mafia, so he had their backbone. I think that's what scared Cohen, Michael, the one that was there, is that he realized when his father, when that started going down, when that whole regime went down, that he realized that anybody could be caught by any little mistake.
Yep.
And I hear that Mocha agrees.
Oh, absolutely. She's like, I am tired of this shit. So tired.
But yeah, I mean, it's weird, all the stuff that's happening, and I keep seeing that it's not just one thing. It's all this shit is tied together, and I mean all the
A
way
multitude, yes.
the e-files, and that's what I don't think anybody realizes how deep ingrained this stuff is. Everybody thinks that it's separate. No, it's not.
It's a workaround angle,
And TikTok, this is only my opinion.
and it's a distraction.
See, I don't.
And they knew how to use the media too.
No, they still do. There's a lot of
Because what does it do? Social media influences all, and ever since the 90s, it's all considered social media.
Well, see, it's funny.
Back in the day, it was what, radios.
Mm-hmm. Oh, it's still radio.
It was the speeches. Even further back, it was the speeches that they attended.
Yeah. So what I'm looking at now is, if you paid attention, remember how he's like, "Oh, we don't want to talk about the Russian interference because it make me look bad and bring our election into question." But yet, what is he doing now?
Same shit.
He's drawing attention that this could be interfered with. Look at these fraudulent things. Which back when he was in.
But look at also the influences from other countries, how they're spinning off their own MAGA.
Mm-hmm.
That's another thing too.
Yeah,
it's a form of control and to curb all the markets and all the market trades and blah 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 and all this deep-seated crap. Yep.
Well, the other thing is, you've heard him say it time and time again. Say anything 3 times and they'll believe it. Tell a lie 3 times, it becomes truth. I mean, it's actually more than 3 times, but
in a roundabout way, yes. Remember, keywords. There's certain keywords with the actions. Katie.
And that's what a lot of people don't realize, is that they do things on purpose for a reason. The way they do it is to draw things out that they want drawn out. Like, if you remember, he said, "Oh, I asked Putin, and he said they didn't involve," and I believe him, even though all his freaking CIA agents, he said no, they were involved. The same people on board for him. Oh yeah, we need to do a deal with Russia. Are the ones that were saying 10 years ago that, oh no, we can't trust Russia at all.
Never been able to. They've been easily enough for over centuries. Centuries they've been like that.
Well, Putin even said, "I'm not going to defeat the United States from outside. I'm going to have to defeat them from within." That's exactly what this is. I mean,
always from within. Always.
That's what a lot of people, they don't understand what he meant by that. And he's got the taco that's taking his side, so that's helping him. Because these people believe the taco.
Stay on message. Stay on message. That's the message.
Problem is he's lost the message now. You don't remember what the message is. Yeah.
And then you tie it back into the Christian nationalism and the fundamentalists. Yeah.
Yeah, those people are only going to deal with whoever's in power at the time and try to sway them.
They're the puppet. We're the puppet master to work with them.
Would you trust if you couldn't just? I'm sorry.
But that's just me thinking like bigger picture. With all of this, like it's what's the bigger picture out there? How is it all coincide with each other? Which it does.
That's the thing that I don't think a lot of people are understanding, is all these little things are intertwined, and until you figure out who's actually driving the individual stuff, you won't know who's in control of everything. Because Putin's not in charge, Bibi's not in charge, Trump's not in charge, Bannon's not in charge.
Distract. They are. Look how long everybody didn't think that Israel was running here.
Oh, Israel's always been here.
So that's what I'm saying. Think of all the people that didn't realize it. I was one of those people too, and didn't think of how much involvement was involvement.
Oh, I'm so well. You weren't probably old enough to realize it, but when I
No, I didn't. Like I said, I recently, I want to say within the past year, like opened my eyes more.
Mine came into place was when we went and did the Desert Storm, and there wasn't a lot of what was being said was not true. They come to find out the real reason that Kuwait was invaded was because Kuwait reneged on the deal, and that's like, oh wait, if they reneged on the deal and that's what government allowed them to do, then what else? And then all of a sudden, that's when we had the WMDs all of a sudden show up in Iran at the time, Iraq at the time. That's why we went into Iraq, just because the WMD's there. And guess who the agency was that told us that they were there? That was Israel Mossad. And that's when I realized we were screwed and getting our information was coming from them. You can't trust somebody that has an ulterior motive, and their ulterior motive is to get rid of Islam at all costs.
Yeah.
See, that's the thing. And then you have the e-files, which Bibi was involved with. I'm 99% sure he was. I know probably for a fact that Putin was, but Putin may not have been directly involved in the child aspect of it and the trafficking to a degree. He did traffic the women from Russia that he put in certain places to get the information he wanted. That's why Russia was sending women so they can get their. That's the honeypot. The whole honeypot scheme. So that's how e-files tied into Russia and that stuff. And that's where they came from. I believe that they got rid of E before he came forward and gave them all the information for two reasons. Number one, they wanted to keep it going. That's why they got Rumpus in office, got Taco into office, so that they could keep it quiet a little longer and hopefully cover up the leaks before it got out. But the problem is those leaks are getting bigger and they're not being able to stop them. If that makes sense to you. I guess I'm talking to myself.
I'm in my head thinking. I'm just wondering, like, how deep has involvement been for how long, and if it's more centuries long than we really realize it.
I wouldn't go centuries, decades, yeah, but I don't think we could go back in the 1800s. I think the biggest part was right around World War I. Okay, you got to start sucking those things up. Yeah, I think the actual real involvement was World War I. Is when that started, and that was and that came into place with the fall of the empire and takeover of the czars. Actually, the czar falling out in Russia. But see, I think the whole thing, KGB and all that, has been going with Taco since the 70s and 80s. Ivana was a spy.
Hello.
Hello, Katie.
Kitty!
Hello.
Katie, I'm glad I'm not alone in that, finding out about Israel lately.
Oh.
So
Yeah.
that feels like it's like I guess I just ignored it.
I don't know if we ignored it, but it was hidden from us. we didn't look hard enough for
Well,
something.
they have the greatest scheme of all. Israel does. Their scheme is religious. Their religion. So they wouldn't do something like that.
And hiding behind the Holocaust.
Right.
And what happened then?
Yeah.
And it just also feels like, well, this is the user effect. That here's the guilt, we'll help you because of this is what, happened. But wouldn't that also be tied to how the, African American community and all the BIPOC community altogether, minorities,
That's
and how everybody was treated from the past?
See, the difference with that is with Germans, they could kind of blend in better with the white people.
Mm-hmm.
And could blend in with the Triple K and all that. It fit into their
Irish,
right.
The Irish too, because that's where it started here.
Yeah, it fit into the narrative of the master race, which was the H-Man's famous thing. There's a master race, you got to make a master race. So that's where the stuff was so easy for them to intertwine into back into us. And why they did not fall by the wayside. Now all of a sudden we had the people that were, oh shoot, look what they did to those people over there. Those Jewish people were totally taken advantage of. Now we have to help them out. And that's when they gave them Palestine.
Yeah.
Well, they actually gave them before that, but that's because this is probably where I saw some things that nobody else has really paid attention to. They said, okay, hey, Jewish people, here's this country down in the Middle East, and we can get you down there in that country, and y'all can have that country so that y'all will be left alone. And hey, it's your motherland. It's where Jerusalem was. So that's where you can be. But they did that, but they didn't let them back in their own homes, back where they came from. So they basically said, fuck y'all call down there and live. We're not going to let you back into our country.
Right.
And nobody figured that out. And then what did the people that went down there in Palestine, what they do? They slowly took it over the years. You go look at the progression of the Israel takeover from 1947 to today. And you see it start growing on the map.
From 47, okay.
Israel, well, they were put in there between World War I and World II. Some of them moved in that area. But the big push was like 47, 48, somewhere right after World War II.
If I thought without saying goodbye, I'm just dealing with stuff, okay?
All right. Oh, got stuff to deal with.
Don't be rude. Say goodbye.
Goodbye.
I'm kidding. I'm kidding. Jeez.
Hey, simply go, hey, I can shut up. Bye. There you go. You said it.
You're right.
You're the king of with I disappear without any word.
Right, which is understandable, yeah.
No, I was making fun of you because you always disappear.
I got reasons.
Half the time she falls.
Yeah. Either I fall asleep, I'm playing a video game, or if I get a text and I accidentally click on that and you have to go back. Yeah.
I was just telling you so you didn't worry.
Yeah.
Always worried. Doesn't matter. It's part of being a Taurus. I always worry. Or Earth sign. Always worry.
Yeah, I guess a lot of this that I've seen because I've been live a little longer and seen the fully stuff and the repeating performances from that area, from the I country.
Well, you've been around longer, so you definitely know. Plus, you've been in the service.
Yeah.
So you have a different perspective as well.
And you're probably a lot more educated than us in that stuff.
Yeah.
Based on experiences, yeah, could be. And then just overall information, collecting and doing research, stuff like that,
Yeah.
It all adds up.
The Jerusalem, I always known that the dipshit lies to us, get us to do things, and uses us as his personal attack the army. I've known that BB has been doing that for centuries. Well, not centuries, because he's not a century old. Has been doing that to us for decades. Because he's found out the button to push to get us to act. And that's the whole Middle East thing with the Muslims are this way, they do this, da 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 da. Is that what they were pushing? Is to unalive all infidels. Now think about this. You know how long that statement has been around? That is centuries, by the way.
I thought so.
It was first used in the Crusades. That was why they went down there to remove them during the Crusades, because they were trying
Not
to
the Crusades.
they were trying to save their motherland.
And don't forget the expeditions that they did. All the expeditions that was tied into it.
I mean, that's the whole thing. Is they've been downing these people for since, I mean, what, 2700, 500 AC, AD.
Well, as the term is called, colonization. Mm-hmm.
And that's what it is. All that stuff's been thrown away, and nobody's kept up with it, so they don't know. They don't remember those facts, and we don't go enough into detail in history to understand that stuff.
And they don't teach it here firsthand. The only time that we will learn is in college, and if we also do extensive research in college about it.
Yeah. How naive I am. I didn't even know about Tulsa until I got on TikTok.
Yeah.
Mm-hmm. It's amazing what information that we've been withheld for so long.
And that's the whole reason that they tried to take TikTok down. It's because they realized that this information was getting out in TikTok, and it was opening people's eyes. So they had to that's why they started trying to foretell it.
And then they originally started also on Instagram and Facebook.
Mm-hmm.
But then they also realized that the long-term resource was YouTube.
Yeah.
Until they started, reducing and restricting. I think they're less restrictive now than they were.
The other thing is someone had got them to believe that Palestine was putting false information out, which they weren't. Mm-hmm. They were taking their information that was happening and going.
Yeah, right in the moment, yes.
And you have, like, Gaza got demolished and had no way of getting their own foods anymore, which is what the whole purpose of what that country did. And then once they did that, these people were so terrible. They would actually say, okay, the food's going to be here. And they would actually use that to...
the flotilla.
Oh, not just the flotilla. I'm talking about they actually had food.
When they dropped it by air?
No. They had they had places they were going to allow food to be given to the Palestinians. But what they would do is they say, okay, they're going to be here. They wouldn't give them the opening time so these people would show up early to get stuff. And while they were waiting in line, the I country people would sit there and pick them off one at a time. Start shooting them.
So is the I country just racist? Or is it beyond that?
I don't understand what you're trying to ask there. The I country is been taken over by corrupt individuals.
I mean, did they not like them because of brown, or is it beyond that?
Oh, no, it's not brown. It's not the brown issue. Okay. Well, the Middle East has always had the Abrahamic religions: Judaism, Christianity, well, Catholicism, Judaism, and Muslim. Catholic was later. Christians are later. But because they're all Abrahamic, and that's what they came from, they all originated there. But now no one wants to admit that they are based upon the same information.
Yeah.
You had the Romans come down to Middle East and Egypt and all that, and that was trying to remove the Muslims out. And some of it was the brown, and a lot of it was the difference in religion, because they don't want. Because some of the people that are running things do not want different religions. Because if there's different religions, they cannot control the people with one religion, which is what they were trying to do with Catholic and Christianity. It was trying to control people using that religion.
Yeah.
Some people may believe in religion. That's all good for them. But I see it as a tool of control. That's what I see religion is.
Isn't it basically what most of the wars have been over?
Depends on how you mean, because World War II and World War I were not because of religion. They were because of, well, I guess it's fascism. It's not really religion that's driving, it's power and control. That's what drives the wars. Which you could tie into religion or you can tie into dictatorship. And that's where I think a lot of people are missing it here in the United States, especially people in Congress, is Trump is narcissist. He wants to be in charge. He wants to be the sole person in charge. So that's what he's pushing for. But they're like, oh, we got this in the bag. There's no way he's going to take over. We have stuff in place. But because they have the idiots that are ceding all the power back to him, they're losing that power. So there's not the true divide. Can we get it back? Yes. Will it be quick? No. It's probably going to. It took us 50 years last time to solve the depression. To get out of the depressive stuff, it took us 50 years. So there's that.
Okay, love you. I gotta go deal with stuff.
Okay.
Bye.
All right, bye.
All right, love you, Katie. See you tonight. Yeah, I'm starting to doze off, but it was a good perfect time for it's 4:56 here. So
yeah, I understand. It's just there's so much in this that has to be pulled out.
Yeah,
and we don't know how long it's going to take to pull all of that out, and hopefully it does pretty soon. But these people are not going to roll over and say, "Here's the information." No, you got to find it yourself. So, yeah. Oh, all right. If you want to go to sleep, I guess I'll let you go to sleep, and I'll bundle all this up, put it on the Substack, and this should be on there probably Saturday. I think I got all the way up to Friday already. Yeah. All right. Talk to you later.
all right.
Thank you for showing up.
Bye.
And bye.
I'll see you later.
Bye.
Bye.
Like, share, follow, and please make sure other people see this. And hey, remember, you are loved no matter what you do. Bye.